Calls case People versus Floyd McFall. Excuse me.
Good afternoon, Your Honor. Constable based on behalf of Mr. McFall, who was present to my right. Can you state your full name for the record, please?
Floyd McFall.
Welcome back to the courtroom, and brace yourself, because today's session is packed with tension, contradictions, and courtroom confrontation. Two defendants, two very different explanations, and one judge tasked with cutting through the noise. First up is Floyd McFall, facing multiple violations tied to alcohol use and an alleged assault involving, of all things, a wine bottle. His attorney argues for leniency, but the prosecution isn't convinced this is a one-time lapse. Later, Megan Moses takes the stand with a story involving a malfunctioning ankle tether, a broken phone, and a scramble to prove she's still trying to comply. Stay with us. This hearing pushes the court's patience to the limit and challenges how much trust a judge should give.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
That brief's complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Mello.
Judge Valvo. We've got. You want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people.
Your Honor, we have concerns about involved like I would note that it's not just one incident, it's two different days, and that the report indicated when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those two on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
And so, Your Honor, part of the reason that we find it concerning, believe that alcohol related involved with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies to bond conditions that he seems to violate it multiple times when he's confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is And I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was a no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No, no. Just at my church, I don't have proof for it though, and I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He's signed
He's
up.
working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded.
Next case on the docket.
Court calls case of the people versus Megan Moses.
That's what people.
Good afternoon, Your Honor. Constable Bates on behalf of Ms. Megan Moses, who was present to my right. Can you state your full name for the record, Ms. Moses?
Megan Moses.
All right, go ahead.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor. As to the violation, Your Honor, my client still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike and like with the pedal, so she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in
I
and
have a
get.
broken phone too. I had my number to the tether guy in my phone and I had no way to contact.
So the tether came off in a pedal. She
No,
broke
it's still
phone.
on. It just pulled it and it poked it. Like there's something poking
Don't-
through
Did you
it.
call community corrections at any point?
That's what I'm saying. I was able to, I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my
Was
phone.
your tether
which
going
was
off?
broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work.
So
So
if
I
you didn't know where to call, what were you gonna do with her phone?
was gonna call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone, explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him, and left a message out until tomorrow, I think, but I was waiting for someone to, contact.
Did you go to the community corrections?
I called them. I did when I finally, was able to figure out who to call when I got the email.
When did you call them?
I called,
How many days after this alarm went
well,
off?
it happened on Friday. And then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she
contact-
doesn't want to comply. Have you been to the community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle, or a phone at the moment, so I was requesting things through email as well, or trying to. I'm still charging it as well, like, I'm not trying not to.
She's not
go
trying
through
to
with this.
she's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It was just, it seems it was just an accident.
Now we shift to a very different situation and a very different kind of problem. Megan Moses claims her court-ordered ankle tether became tangled in her bike pedal, causing it to malfunction. Add a broken phone, limited transportation, and communication gaps, and her explanation quickly turns complicated. But the judge and prosecutor notice something concerning. Details start to change as she explains herself. And in court, credibility is everything. Even small inconsistencies can raise big doubts. So here's the question. Was this truly an unlucky chain of events? Or an excuse that doesn't quite hold up? If you were on the bench, would you believe her?
And just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So
Yes, but I
Don't
don't
have a right.
understand why she didn't.
she hasn't even secured a ride back yet today. So
Yeah.
she her
But
transportation.
why she didn't keep in contact more with community corrections?
I think it's due to
I mean,
her
this
lack
thing
of.
went off almost 10 days ago.
Well, I was
And we
waiting,
don't,
I'm sorry.
go ahead.
Apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come. And left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this
Oh, I
point.
don't-
She still has the tether on. She's still been charging it. She's still.
What is,
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So so the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI third, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people. It's something I picked up on. I think the court picked up on it too, as I
Yeah, I did.
So I'm just worried about what's gonna happen.
I don't think I'm being told the truth, in all honesty.
I understand where,
Your Honor, I understand, but I, as I said, the purpose of the tether was for her to come back to court. I'm not sure why there's concerns if she's in court here today. And she's saying that she just misspoke because she's very nervous, Your Honor. She suffers from anxiety.
Probable cause conference will be adjourned to September 4th.
And with that, the court wraps up a tense double feature. Floyd McFall's outcome is clear. Bond revoked and remanded into custody. As for Megan Moses, she's granted a temporary reprieve, though the court clearly notes the weaknesses in her explanation. This hearing is a reminder of how fragile second chances can be. One violation, one mistest, or one story that doesn't quite add up can change everything. If this breakdown caught your attention, hit like, drop your thoughts in the comments, and subscribe for more real courtroom drama every week. Until next time, stay alert, stay informed, and keep watching the bench.